Folks, sorry about the delay. We had to complete another hearing.
Good afternoon, Your Honor.
Good afternoon, sir. We're on the record in case number 24 CRI 184, cases captioned State of Ohio versus James D. Taylor. We're scheduled today for initial hearing in bond stating the complaint filed the court on May 28, 2024. We'll conduct this hearing by video. State of Ohio is represented by prosecuting attorney Christopher Tennell. The defendant is also present represented by attorney Patrick Farrell. Mr. Farrell, can we first proceed? I'm sorry. Mr. Taylor, any objection to the court conduct this hearing by video?
No, sir.
We have no objection, Your Honor.
Okay. Mr. Farrell, can we first proceed with an arraignment on the complaint?
Yes, Your Honor. With respect to the arraignment, my client has been served with a complaint in this particular case. He has that right presently in his possession. He is unable to read the complaint because he does not have his reading glasses. However, I have explained to him the charges and the maximum penalties that are contained in those charges in the event he would be convicted. My client has indicated to me that he would waive reading of that complaint, and he would also request a plea of not guilty be entered on his behalf. And we would like to be heard with respect to bond, Judge, or Your Honor.
Thank you, sir. Court will accept the not guilty plea. Mr. Taylor, as far as preliminary hearing, what's your client's position?
What's that, my honor?
I'm sorry, Mr. Farrell, what's your client's position as far as preliminary hearing?
We would request a preliminary hearing if we could be afforded one, Your Honor.
Okay. Mr. Tell, any position as far as when we schedule the prelim? It looks like we have to schedule it by.
Well, can I ask this question? Can I ask this question before we schedule a preliminary hearing?
Yes, sir.
Is the prosecution, have they made a request for bond?
Not yet. We'll set bond today. Do you want to do that first, sir?
Well, I'm thinking that if the bond is something that's doable for my client, that maybe we could waive the preliminary hearing at this juncture.
Okay, we'll go ahead.
I don't know what their recommendation on the bond was going to be.
Okay, we can go ahead and set bond. Mr. Tennell, what's the state's position on bond?
Thank you, Your Honor. Your Honor, the court should be advised that on May 24th of this year at approximately 3:30 in the afternoon, the defendant was operating a motor vehicle on County Road 681 in Sullivan Township, Ashland County. In the course of his operation of that motor vehicle, he struck a 12-year-old child who was riding a bike. That child was provided medical treatment at the scene, life-flighted, but unfortunately succumbed to the injuries from the accident later at outside hospital. Investigators at the scene found the defendant to be clearly intoxicated. They attempted to initiate roadside tests. The defendant cut them off and refused to go further. And then he subsequently refused a chemical test. Investigation did result in a search warrant for blood, which was drawn at the hospital and sent to the OSP lab. So those are pending results. Further, there was some unidentified crushed powder found in his wallet. That was likewise sent off to the lab and is pending results. The court should know that the defendant from the Ashland Municipal Court has a 2014 physical control while under the influence conviction, got a 2018 high tier OVI. And while ordinarily it doesn't come up, but in this context, the court may find it relevant. The defendant was convicted of failure to control in Medina Muni in 2001, in Ashland Muni in 2008, in Wayne County Municipal Court in 2013, and in Barberton Municipal Court in 2023. It also appears at least from the Oleg and Leeds printouts, that he lost a CDL in 2018, presumably in conjunction with that Ashland OVI. The state would recommend, as far as bond, the court's standard conditions. Additionally, no contact with victim's family, no operation of a motor vehicle whatsoever, which shouldn't be a problem given the suspension for the refusal, and $100,000 cash.
Thank you, sir.
Thank
Mr.
you.
Farrell, what's the defense position on bond?
Your Honor, with respect to that, the bond of 100,000 in cash, I think that we would request that that be 100,000, 10% bond. My client has been an outstanding member of this community for his entire life. His family was born and raised here. He raised his family here, his brother's here. He's got sisters and sister-in-laws here. He is a member of the church. He's a trustee at the church in which he attends. I think with those factors being considered, that 100,000 cash surety bond might prohibit him from being able to make that particular bond, Judge. And we would like to discuss this case with my client, and it's much easier to do so outside the confines of the county jail. So I would hope the court would take those into consideration. I think what else he's got? Oh, he's got grandchildren as well, Judge. So I don't think he poses a risk to society. I don't think he poses a risk of flight under the circumstances.
Thank you. Mr. Taylor, to be released while the case is pending, you'll have to post 2 bonds. First bond is a person reconnaissance bond. That's your written promise to the court to appear for all future hearings. If you would fail to appear for a hearing, be prosecuted for the separate felony offense called failure to appear. That's a felony of the 4th degree. In addition to this case, court's also requiring you post a bond amount of $100,000. That can be posted with a surety bond, cash bond, or real estate posting. If you post bond, you're subject to the following conditions. 1, you're not to leave the state of Ohio while the case is pending. 2nd, you must appear for all future hearings in this case. 3rd, you must keep the court advised of your address and phone number at all times. 4th, you must obey all laws and orders of the court. 5th, you're not to use, consume, or possess any alcohol or drugs of abuse. You also be subject to RAM, drug and alcohol testing at your own expense. Further, sir, if you post bond, you must go to a drug and alcohol treatment provider, obtain a treatment, status comply with any treatment recommendations. You have to make that appointment within 14 days of posting bond and provide verification to the court of doing so. Further, sir, if you post bond, you must enroll in the court's drug and alcohol testing program. Further, sir, if you post bond, you are not to operate any motor vehicles while the case is pending. Further, sir, if you post bond, you have no contact whatsoever with the victim's family. Finally, sir, if you post bond, you will be subject to GPS monitoring. What that means, sir, if you post bond or bill subject to GPS monitor, you have to wear that while this case is pending. While on GPS monitoring, a curfew must be at your approved residence during the hours of 9 p.m. to 6 a.m. Further, sir, you'll be responsible for all costs associated with the GPS monitoring. Mr. Taylor, do you understand the condition of bond?
Yes, Honor, I do.
Thank you, sir. Mr. Farrell, then, do you want me to go ahead and schedule the preliminary hearing?
If you would, Judge, do you have a copy of the preconditions of making the bond so that we would have a copy to review?
I'll have that order posted before I leave today, sir, and then you'll get a copy of that.
That would work. Thank you, Judge. I'd appreciate it.
Yep. Ms. Shell, any preference when you want the prelim scheduled? We could do Friday or Monday. I know your office is booked solid on Monday, but
Yeah, Monday looks bad. So Friday, pretty much Friday or nothing, huh? So
What is Friday? Are you talking of Friday the
Friday, May 31st is coming Friday.
31st? What time would you conduct the bond hearing? Or not the bond hearing, the preliminary hearing, sorry.
The prelim, we're gonna have to, I have a hearing all day, so we're gonna have to schedule this over this. This case takes precedence, so I can do any time between 10 and 4.
If we would be able to conduct that sometime in the AM, I would appreciate that.
Okay. Ms. Shell, would 10 o'clock work for your office?
We'll make it work.
Would 2 hours be sufficient? I guess we can go 3 hours easy.
I should hope so.
Okay. We'll set the preliminary hearing for this coming Friday, May 31, 2024 at 10 a.m. Ms. Shell, any preference? Do you want to do that in courtroom 2 or by video?
I'm okay. I'm okay with video
Okay.
unless there's an objection from the defense.
Mr. Farrell, any preference? Do you want to do the hearing in court or by video?
We would have no objection to doing it by video, Your Honor.
Okay. We'll do it by video then. All right. Mr. Farrell, anything further we can address today, sir?
Not on behalf of Mr. Taylor, Your Honor. I appreciate it.
Ms. Shell, anything further?
No, Your Honor, thank you.
Thank you all. We're adjourned.